to my 3 kids as 1/4 to each kid, 1/4 divided evenly among these 3 grandchildren, but held in trust. Okay, so what does that mean? Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today we're going to talk about an estate that ended up being destroyed by a couple of attorneys who really didn't know what they were doing, and it's very likely that they were what I call also attorneys. So they've got a main practice in divorce, but they also can do estate planning, and perhaps they've got this big practice in personal injury, but oh yeah, I suppose I could do a trust or a will, and they also do these things, so they don't really focus on it. And I'm saying this because some of these mistakes are so basic to estate planning, and yet they still got it wrong. Now, unfortunately, this case that we're going to go over is something that is actually happening now. Of course, we're going to use different names to protect everyone, but lay out the facts and show how that an estate can go very, very wrong by just a few basic mistakes. And they're going to be 5 big mistakes in this instance. So we're going to have the Smith family. This is the hypothetical family that's putting everything together, going back to 1996. We're just going to pick a year, 1996. They decide that they heard about this revocable living trust. They want to set up their estate the right way. They want to protect their inheritance that they're leaving to their 4 children. They want to make sure that everything goes smoothly and doesn't have any kind of probate court. And they end up going to an attorney, and I'm assuming it was recommended by a financial institution. And I'll get to that in a little bit as to why I believe that's what happened. So the financial institution sends them to this attorney. They set it up, and here's the name of the trust. It's the Smith Revocable Living Trust. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. No date, no names of trustees, just the Smith Revocable Living Trust. Now this becomes important as we move through this story. So they set it up, and we're still trying to see what was actually put into the trust. All right, so what are these big mistakes now that happened? Okay, the first thing is after Dad passed on, after John Smith passed on, Mom went to a different attorney, I'm assuming referred by the same financial institution, and she needed to get the trust updated. Another thing that had happened was one of their children actually passed on. So one of their children, and they had 3 children, meaning their grandchildren, they wanted to make sure that the beneficiaries were all set up. So they go to another attorney, and they set up a new trust for Mom. Oh, what did they call this new trust that was set up in, say, 2021? The Smith Revocable Living Trust. The same exact name. They picked the exact same name. Okay, what else went on here? Apparently, it was from the same financial institution that sent them to this new attorney because they ended up using what looks like some of the same exact form documents of an extraordinarily basic trust. So this isn't something that I've seen before. It wasn't, oh, this was created by a template from the state bar or from some research group or some major group, but it was the exact same thing. And sometimes banks and financial institutions put out their own templates. Here, attorney, you go ahead and do whatever you want. It was almost exactly the same thing, except it was written for an individual, but they used the exact same name. Nowhere in that trust did it say that it was an amendment and restatement of the old one. So now another potential issue that could come up is, what if there were assets funded into that old trust with that name, but now we have a new trust that's just mom with the exact same name and no other distinguishing features? Okay, that becomes an identification problem that could end up with something thrown into court. All right, so that was the first big mistake, using the exact same name and no alternative or identifying language. What's the second big thing? When they listed out the beneficiaries in the 1996 trust, in the 2021 trust, they did the exact same thing, which is one of the most basic things that attorneys learn when you're drafting estate planning documents. They didn't use per stirpes or per capita. Well, all right, what does that mean? And this is a good explanation, because I get this question all the time as a very basic one when people are starting the research. What's the difference between per stirpes and per capita? Per capita means among each. So if you've got 4 kids and one of them passes on, all right, that estate only gets split 3 ways. That's per capita. Per stirpes means, well, it's going to follow down through the bloodline. So if you've got 4 kids and one of them passes on, but the kid who passed on has 2 kids of their own, all right, those 2 kids are going to split that 1/4, and the other 3 kids each still get their 1/4. So that's per stirpes, meaning it goes down through the bloodline. This trust, actually both versions of the trust, didn't say per stirpes or per capita. That's like one of the most absolute basic trust drafting things that you do, is you put that in there. And it had been a long, long time since I had actually had to review this for the bar exam, because it was that long ago. I was like, wait a minute, what's the default language? And I started looking, and there's all these cases on, well, we're going to use context clues to see what did they mean if it's not mentioned, and then eventually got to the answer of what it is. It does end up being per stirpes, but they always look at these context clues first, which means it could end up in court. If the kids wanted to fight the grandkids, meaning the three grandchildren of that Smith child who passed on, if they wanted to fight because they wanted a bigger share, it's going to end up in court to look for the, quote, context clues before you apply the, quote, anti-lapse statutes. So that's a huge mistake. All it took was just the most basic drafting skill to put per stirpes or per capita to explain what happens, but they didn't do this. And the template didn't really call for it. It didn't have a default written in, and therefore the attorney just kind of let it go. Well, yeah, okay, we're going to list this. So in the 1996 version, it listed the 4 children. In the 2021 version, it listed the 3 grandkids, but still didn't put per stirpes or per capita. So have to keep the fingers crossed nothing happens to any of the other beneficiaries before this gets distributed. So there we go, 2 down, 3 to go. This is a big one, and this is actually a different attorney. I don't know if they were recommended by the same financial institution or not, but this real estate attorney, they were moving the house into the trust back in 1996. So now remember, the name of the trust was the Smith Revocable Living Trust. Got a copy of the deed, and it says the Smith Trust. Okay, is there any other trust? Because the name of the actual estate planning trust is the Smith Revocable Living Trust. That's not what was on the deed. So now we got to go to court potentially and find out. Now, here's where it's not a legal, but could be a practical nightmare. It's because if it's not effectively put into any trust, then it's very likely that it's going to get, quote, thrown into probate. And now what was supposed to be the very easy sale of the house by the trustee, one person signing off and getting it sold, and then the proceeds divided among the beneficiaries, Now, suddenly, we have all of those beneficiaries having to sign off, not because the law says so, but because the mortgage company of the buyer is going to insist upon it. Very, very, very likely. So now they're going to want, quote, the protection of the probate court and all the beneficiaries signing off on the sale to make sure that they're not lending money on a, quote, risky titled asset. And now the real estate sale is becoming more of a nightmare tied to the probate court. All of that should have been avoided if it had simply listed the proper name of the trust that was given back in 1996. Then it wouldn't have been an issue. It would have been an issue with probating and all the other stuff that has to happen. Technically, it should have gone from the 1996 trust and been deeded over to the 2021 trust, but that didn't happen either. So, 3 down, 2 more to go. There was no moving the personal assets into the trust. Now, in my firm, we use something called an assignment of furnishings and personal effects. It's just kind of a form that's overarchingly saying anything that we, the trustors, in this case, it would have been John and Jane Smith, or even after John passed on, Jane Smith, saying all this collective loose stuff that doesn't have title paperwork to it, we're moving into the trust so that doesn't have to go through probate. Okay, so now, because of this quote, oversight, and sometimes there are attorneys who do this intentionally to get the probate work, it's going to have all of the furniture and furnishings, the personal effects, the clothing, all of it has to be accounted for in probate court. And, well, now that's huge. Why have to have that happen? And here's the thing. In North Carolina, the fees that you have to pay the court are based on assets just like that and other things, bank accounts and whatever. It's the quote. There are 3 sections in the probate paperwork. It's the section 1 assets, not the stuff that was pay on death or joint with the right of survivorship or, otherwise transferable. It's the stuff that was, quote, actually in probate. Those Schedule 1 assets, it's a percentage based on that. So now there are fees being paid to the probate court that didn't need to be there because the attorney didn't have a 1-page form to move it over. So again, that leads me to think this was, quote, an also attorney in 1996 and also 2021. Okay, so now this stuff has to go through probate. Well, okay, this is where a pour-over will. Whenever you draft a trust, you do need a will, but the will should simply state anything that ends up in probate goes to the revocable living trust, and therefore you don't have to disclose the beneficiaries. Nobody really knows what the plan is. It ends up having to go through probate, but then it's just going into the trust, so nobody really knows who the actual beneficiaries are. And the only person who has to sign off on the paperwork accepting the assets from probate is the trustee. And very, very typically, and it's one of our strongest recommendations, is you make the trustee list line up with the executor of that pour-over list. So one person is having to sign this paperwork to accept it into the trust, and then they can start distributing stuff out of the trust. What did this attorney in 2021 do to Jane Smith's last will and testament that was supposed to be a pour-over will? I leave all of my personal effects, furniture, and whatnot to my 3 kids as 1/4 to each kid. They listed out each kid in 1/4 divided evenly among these 3 grandchildren, but held in trust. Okay, so what does that mean? Yeah, it ends up eventually going over to the revocable living trust, But now you've got 3 kids and 3 grandkids who have to sign off on all of this beneficiary paperwork as part of the probate court process. So now you've got not just the trustee, who happens to be one of the kids, and the executor is one of the kids. We have 6 people who have to sign off on all of this formal paperwork because the attorney in 2021 couldn't just say it goes to the trust and cut it off there. They've created additional probate paperwork that did not need to be there. So it does make you wonder, did they do this intentionally or not? So these are 5 very big mistakes. These are 5 very big mistakes that really come down to very simple things that should be happening with attorneys who are in estate planning at all in any fashion. These are things that should not happen, but they did. So let's go ahead and we're going to recap those 5 huge errors. There were 2 trusts with the exact same name without any additional identifying language and without saying that the older one was an amendment and restatement of the old one. Okay, that makes it confusing enough. There was no per stirpes or per capita language for the beneficiaries, so all right, it could end up in court being contested because the courts look for, quote, the context clues before going to, well, if it really does say nothing, then here's where it goes. This is one of the most basic things that every drafting attorney knows you put in per stirpes or per capita based on the wishes of the client. Third thing, the deed went to a trust that doesn't exist. They used the wrong name in the trust, so that house transfer now could have a huge amount of additional paperwork because the kids are trying to sell the house, which is what everybody was intending. Fourth thing, they did not move personal effects and assets over to the trust, so all that ends up in probate. And fifth thing, the attorney drafted the will listing all of the beneficiaries and then putting, but held in trust under this trust instead of just sending it to the trust. So now all of those beneficiaries have to sign off on paperwork. This is a lot more of a nightmare than it needs to be when you're working with a revocable living trust. If you want to learn more about how to set things up the right way, check out the freetrustcourse.com. I put up a free program that runs through the basics of estate planning, including how to work with a revocable living trust. But even more importantly, don't work with an also attorney who doesn't really know what they're doing in this case. They really should be understanding at least these 5 basic things were huge errors that never should have happened by anyone who does estate planning. So, look, I hope you got some really good information out of that. Maybe you're checking your own estate plan, or if you don't have one in place, this is going to be a little bit of a kick to get going and get your own estate set up. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.